Hello. This video will teach you about what happens once a mortgage foreclosure lawsuit is filed. A foreclosure lawsuit is usually filed after you've missed 3 mortgage payments. The lawyer for your lender will start the process by filing a complaint in court. The lender is the plaintiff and you are called the defendant. The law requires that you be served with a copy of the complaint and with a summons. You might receive those documents by someone delivering them to you, or they might come in the mail. If they come in the mail might be addressed to you or to unknown owners. Remember, you do not have to move just because you received those papers. Do not ignore those papers. You should do 3 things when you receive the papers. First, try to talk to an attorney. Second, call your lender. Third, file your appearance and answer in court. An attorney can tell you whether the papers were served in the right way, if you have any defenses to the lawsuit, and can help you work with your lender. Be sure to search the Helpful Organizations section below to find free or low-cost legal assistance. You should talk to your lender about alternatives. You have 90 days from the date you were served to bring your payments up to date. This is called reinstatement. You can discuss your options for reinstatement with your lender, such as a payment plan or a change to the terms of your loan. The law gives you 30 days from the date you were served to file an appearance and answer. The summons will tell you where to go to file those things. If you file an appearance and answer, the law says that notice of all future court proceedings must be sent to you. If you do not file the appearance and answer, you might not receive important notices. For example, you might not know when your house will be sold or when you may be required to move. The next step in the court process is for the lawyer for the lender to schedule a court date to get a judgment against you. This could happen any time after 30 days from the date you were served. You will probably receive a notice in the mail. You can also get information about the status of your case by checking the records of the clerk of the court. You should not ignore your court case or any notices sent to you. Be sure to attend all your court dates and be on time for court. Do not move. You don't have to move out of your home until the judge tells you that you must move. This can usually take 7 months or more. A normal foreclosure case in court involves the judgment of foreclosure and the order approving sale. It is not until the order approving sale is issued that a judge will tell you you have to move. The order approving sale will normally be issued no less than 7 months after the case is filed in court. Know what is happening in court. The process will usually take at least 7 months. If you do not participate in the court process, you will not know if and when your home is being sold. The judge cannot give you any extra time to try to save your home if you do not participate. If you are unable to keep your home and it is sold in foreclosure, you still have options. There may be money left over from the sale, and you may be able to get some additional time before you move. Your lender may be willing to work with you and do what is called a workout plan. Exploring the possibility of a workout plan is sometimes called loss mitigation. The resulting plan is often called a forbearance or repayment plan. Basically, this is a way for you to repay what you owe on your mortgage over time without bringing the mortgage current all at once. Often, the lender will ask you to pay a lump sum toward what is owed, then something like 1.5 monthly payments per month for a set period of time. Or, the lender may agree to put your missed payments at the back of the loan. Sometimes, the lender will even be willing to reduce your interest rate. The important thing is to contact your lender and try to work something out. The sooner you contact your lender to pursue a possible workout plan, the better. The process may take a long time. Each time you talk with a representative from your lender, you should take notes, including the date, time, name of representative, and what was said, including the next steps. Make sure to get any agreement from your lender in writing and keep a copy. Your foreclosure case will likely not be dismissed until you have completed the workout plan. You may want to contact a HUD-certified housing counseling agency to help you pursue a workout plan. These are nonprofit agencies certified by the U.S. Department of Housing and Urban Development. They will not charge you a fee. You may have legal defenses to the foreclosure action. You should have an attorney review your loan documents to make sure that the proper disclosures about the loan were made to you when you obtained the loan. However, certain remedies are only available to you for a limited period of time. It is important that you act right away and that you do not ignore the situation. If you have refinanced recently and are facing foreclosure, be sure to have an attorney review your loan documents within 3 years of the date you obtained your refinance loan. Bankruptcy is not for everyone. It's most appropriate for homeowners who have suffered a temporary setback and are now in a better financial position. Do not listen to attorneys or others who tell you that bankruptcy is your only option. Instead, talk to a good attorney who knows all the possible solutions when you're behind on your mortgage. These solutions may include bankruptcy, but a good lawyer will never tell you that bankruptcy is the only option for a person who is behind on his or her mortgage. Once you file a bankruptcy, the foreclosure case will be stopped, at least temporarily. When you file a Chapter 13 bankruptcy, you are asking the bankruptcy court to approve a plan where you make monthly payments to catch up on your mortgage debt, and possibly other debt, over a period of 3 to 5 years. To succeed in a bankruptcy, you must be able to afford the bankruptcy plan payments and continue to make your monthly mortgage payments. If the court does not think you can afford the plan, or if you do not make your plan payments, your bankruptcy will be dismissed and the lender will be allowed to go back to foreclosure court. When you go to court, you should tell the judge if you did not receive the summons and complaint. You should also tell the judge if you are doing anything to try to save your home. This includes any options you are discussing with your lender. Bring any papers with you that will help show the judge what you are doing. You should also tell the judge if you have hired an attorney or if you are trying to hire an attorney. At the first court date, the judge can continue the case or the judge can enter the foreclosure judgment against you. If the case is continued, be sure to get a copy of the judge's order that indicates the next court date before you leave. Be sure to go to court on the next date listed in the order. If the judge enters judgment against you, you still have some rights and you still do not have to move. You have at least 90 days to pay off your loan. This is called redemption. You can pay off the loan by refinancing or selling your home. You may request additional time from the court to sell your home. You should also continue to work with your lender on all options to save your home. If you do not pay off the loan or work out some other agreement with your lender, the lender will sell the property at auction after those 90 days run out. You do not have to move out before the sale. After the auction is held, the lawyer will schedule a court date to ask the judge to give possession of the property to the buyer. Generally, the law allows you 30 days after that court date before you must move. Remember, you should continue to try to bring your mortgage current or pay it off. You should also try to work something out with your lender. Do not ignore papers from the court, and be sure to file your appearance and answer. You should attend all court dates and tell the judge about any plans you have for bringing your mortgage current or for trying to sell your home. When the judge allows the lender to sell your home, the home may sell for less than what you owe the lender. The lender may seek collection on the amount still owed to them. If this happens, you will have a chance to appear in court. At that time, you should consult with an attorney about your options. Bankruptcy is not your only option. You may be able to settle your debt by negotiating with the lender. After the sale, the plaintiff's attorney has to come to court to approve the sale. This is called the confirmation of sale. At this time, the judge will give any person living on the property 30 days to move out. If you need more time, you can come to court to the confirmation of sale proceeding and ask the judge for more time, or you can later file a stay of possession. A stay of possession can extend your time on the property an additional 30 days. You must file your paperwork asking for the stay of possession within 30 days of the confirmation of sale order. The house may sell for more than what you owe the lender. The extra money left over from the sale is called a surplus. If there is a surplus, after all debts against the house have been paid, you can go to court to claim the remaining surplus. You should not respond to any offers to collect the surplus for a fee or percentage. The process is designed so that you can collect your own money without any help from an attorney. When you appear in court, you will need your picture ID. The judge will then ask you some questions under oath. It is important when you fill out your paperwork that you send a copy to each party in the foreclosure case. No exceptions. The parties are usually listed on the order approving sale, which is available in your file in the clerk's office. If the lender buys the property for less than what you owe them, according to the judgment of foreclosure sale, you have the right to buy the property from the lender at the same price the lender paid at the foreclosure sale. This is called the special right of redemption. Beware of investors who say they will buy the property inexpensively and allow you to continue living there. Remember, you may have a number of options available for avoiding foreclosure. You may be able to refinance your mortgage, pursue a workout plan with your lender, present defenses to your foreclosure lawsuit, file for bankruptcy, sell your home, enter into a reverse mortgage, or get your lender to accept a deed in lieu. The important thing to remember is to pursue all your options and not ignore the situation.
LegalShield offers members attorney access for unlimited legal topics for as little as $17 a month. This means you can talk to an attorney about any legal issue you can think of without shelling out a small fortune to do it. Think about it. Affordable attorney access for any legal issue. Sounds too good to be true, right? So, how do they do it? 3 words. Dedicated Attorney Network. What's a dedicated attorney network? It's a framework that enables members to pick up the phone and call an accomplished law firm in their state or province that is ready and willing to help with any legal issue. Because LegalShield pays these top law firms in advance, the 1.4 million families LegalShield protects receive access to quality attorneys for just a small monthly fee, as opposed to high hourly charges. And LegalShield works with partner law firms in 49 states and 4 Canadian provinces, ensuring you're taken care of by an attorney who knows the law in your state or province. Being part of the LegalShield family also gives you more leverage than calling a random law firm as an individual. And because our attorneys are paid in advance, they're both motivated and obligated to provide the best possible legal assistance.
When you call LegalShield, they're very calm, they're very organized, they're very professional, and the service is fantastic. They call you back very quickly. I always make sure I'm organized, I have my questions ready, they appreciate that. But I'd never feel like I'm rushed, and I normally, they go above and beyond with their consultations and tell me things that I didn't even ask for above and beyond the call of duty.
LegalShield only works with quality law firms, with each partner firm being in good standing with their bar association and firms averaging 13 years of being a part of the LegalShield team. In total, they employ more than 1,100 dedicated attorneys, averaging 19 years of professional experience, as well as over 5,000 partner attorneys, bringing a quality approach to over 40,000 calls a week. Even better, with LegalShield, you know who your law firm is. With the ability to pick up the phone, call the law firm directly, and speak to someone who genuinely wants to resolve any problem you're facing.
Satisfaction of the member is our #1 priority, to address their legal needs and make sure that they have a fulfilling experience and that their matter is addressed in a thoughtful and professional way and hopefully resolved in a positive way.
LegalShield is also committed to providing the best customer experience possible, with every partner law firm carefully chosen for its ability to provide caring and responsive legal service when you need it. as well as obtaining only the best results. And Legal Shield continually solicits customer feedback to ensure provider law firms are approachable and effective as possible.
The problem's always been that to have a big law firm to help you has always cost so much. But with your Legal Shield network, you now have quality-conscious, service-oriented law firms and lawyers at your call every day. In fact, I am very proud to be a Legal Shield provider attorney for the last 25 years.
Legal Shield doesn't just provide legal protection. Legal Shield provides outstanding, affordable legal protection with a dedicated attorney network that can't be beat. So, make sure that no matter what you're facing, you'll always have an expert attorney in your corner. Join Legal Shield today and get ready to worry less and live more.
So you're saying I can ask this cat any question?
The cat is connected to the computer. You just type in the question, it will read his mind. There the answer comes.
You're the man! I've been looking for this for weeks.